Introduce Mackenzie Long. So he's an attorney here. He's Westport born and bred. He does have offices right next door. He's been in, he'll tell you a little bit more about himself, but he's decided to go in business for himself. We kind of connected as he was moving in here, just kind of through proximity. We referred clients to him. We've talked about different cases. So he's here for you guys to pick his brain and ask him about basic estate planning. So hopefully you guys will have some questions.
Perfect. As she said, my name's Attorney Mackenzie Long, Attorney Mac, Attorney Long, Mac, Mackenzie, doesn't matter to me. Very informal most of the time. As she mentioned, I did go out on my own about a year ago, so I've got about a year on my own, and I've been in the real estate law realm for going on 4 years now. Been sworn in November of 22. So new attorney, but a lot of experience in this. I did start working in the real estate realm in 2020 before the rates went crazy and refinances were off the charts. So I have a decent amount of experience with that type of stuff, as well as the estate planning and all of the things that go along with it. So basically my intention here is I'm going to give you some general information and facts about estate plans. I will say every single person's estate plan is different. Everybody has a different goal, different family members, different background, different assets. So it's not a one-size-fits-all sort of situation, but there are general things that apply to everyone and can at least give you some basic facts that we can then, go on from there. And, if you're interested and want to do a more formal estate plan, we can set up in a time. You can email me, give me a call. If you have questions, I'm going to do at the end of this, I will ask that you just hold questions if you want to write them down and then ask me at the end after I finish presenting. I'll go over things. If I feel like it's a little bit more in depth than we want to dive into here, we could set up a time, do an email, vice versa, and kind of go into it from that. So that's a little bit about me, but I will kind of dive right into it and get started. So first thing is, what is an estate plan? I'm sure everybody hears all of this and, there's a whole lot of information. You Google it, there's 15 different attorneys trying to sell you on their services. I'm one person, I became an attorney to help people. I watched my parents get screwed over on a bad deal when I was like 15 years old, and I said, I'm gonna go to law school so I can learn and understand what happened, what went wrong, and how I can fix that. So I'm not here to sell you an estate plan. You want to use me, you want to use the attorney down the street, it really doesn't matter to me one way or the other. I'm here to give you information and hopefully help you understand what this all is and why it's important. First question right off the bat that I'll address is, why is an estate plan necessary? And it's not a simple answer to that question, but I think the overarching reasons are important. First and foremost, nobody likes to give money to Uncle Sam. You all meet with them regularly, I'm sure, to plan your finances accordingly, to stretch money, make things grow. You don't want to see it go to the government after, something unfortunate happens to any of us in here. Now, I'm in law school, I'm 19 or 20 years old at this point. I don't have really anything to my name. I don't own a house, I barely own a car. My law school professor says, you're a fool if you don't have a will. Why do I need a will? What's the purpose of it? I don't have anything. And I learned very quickly. I could walk out the door tomorrow, get into a car accident, and get killed by a drunk driver, a freightliner driving down the street, loaded up with equipment. Some guy's truck rolls over on top of you, and now you have a wrongful death lawsuit. And you are worth $1 million from their insurance company for a wrongful death claim. If you don't have a will, there's nothing to govern that. 20 years old. Would have never expected anything to happen, but as we know, life changes in an instant. Anything can happen. So that's a right off the bat reason why you want to have a will. Even if you think, oh, it's not necessary, it's always necessary, regardless. So from that, reasons why we want to have a will, one, makes things easier after you pass. We want to make the transition as smooth as possible. End goal for our passing is to die with nothing in our name. We do not want to own any assets at the time of our death. That is the #1 goal of an estate plan. Like I said, it's not a one-size-fits-all. Everybody has a different size estate, assets are different, et cetera, and so there's no tailor-made plan for everybody. But basic reasons for doing it: Avoid taxes. Like I said, we don't want to give it to Uncle Sam. If you don't have an estate plan and you die with $10 million in your name, you're going to give a large portion of that to the government, both the federal government and the Massachusetts government. When they get the opportunity to collect, they love it because they make out very well. And you worked your whole life to build up this massive estate or whatever you have a house, bank accounts, and you watch some of it go back to the government. We don't want that. So number one, avoid taxes. 2, avoiding probate. Anybody familiar, heard that word before, know what probate is, had somebody in your family go through it with relatives? Gets very expensive very quickly. Attorneys like to charge anywhere from $3,000 to $50,000 to do probates, and it really depends on what attorney you talk to. There are some attorneys that make a living just strictly doing probate, and depending on the size of the estate, the amount of money, assets, etc., that usually dictates what the cost will be. But simply going to somebody like me as opposed to a Boston attorney, just that in and of itself could be a difference of 10 grand. It's very simple in terms of how they price things. Lastly, we want to make it easier on our loved ones. They're already going through a tough time having lost somebody that they care a lot for. The stress and confusing nature, especially without a will, makes it very hard to navigate because there isn't just a cut and dry answer. Depending again on many factors, you'll hear me say that, it's a big lawyer thing. We always say it depends, but overarching is it will be more complicated without at least a will. From there, if you don't have a will or any form of an estate plan, you open yourself up to probate fees, probate attorney fees, you open yourself up to taxes, et cetera, et cetera, et cetera, and that all compounds. So you could have a massive estate and you don't have an estate plan, you could wipe out nearly half of it between estate planning fees, taxes, probate, et cetera, et cetera, et cetera, so forth. So I'm going to dive into now a little bit of the different types of plans. The most basic estate plan: a will, a power of attorney, and a healthcare proxy. Those will take care of your majority of things. It's not the ideal situation. As I said, we'd have to talk about what kind of assets you have. You have real estate, what are your bank accounts, those sorts of things. But basic principle: a will, a power of attorney, and a healthcare proxy. I'll start with the will. The will is a document that we draft that memorializes your intention. I want X to go to this one, I want this to go to that one, my rings, my car, my etc. to this person this way, administered accordingly. It is the most cut and dry, straightforward way so that after you pass, somebody has something written by you, signed, attested, witnessed. This is what I want. The court loves it. The court likes to look at that and see, oh, okay, perfect. This is exactly what Linda wanted before she passed away. We know it's written, it's signed, clean and clear, no questions asked. So, most people have heard of a will and kind of get the gist of what a will does. I'll move on to a healthcare proxy. Healthcare proxy. As we all get older, or anything, doesn't matter your age, something could happen. And if you're rendered incapacitated, a healthcare proxy allows another person, a spouse, a sibling, a parent, a child, to make decisions on your behalf. Whether that may be pulling the plug, if the unfortunate time comes to it, what type of palliative care you want, are you an organ donor, do you want to be cremated, all of those things go into a healthcare proxy and gives authority to somebody else to make these decisions for you. We hope that you never need it, but in the unfortunate event that you do, it's good to have it. And it's very simple and easy to do. There's no timeline on it. You can put a timeline on it. I don't recommend it, meaning like this healthcare proxy will expire in 10 years. If you do something like that, then you want to update it. You can do the same thing with a will, but typically we don't advise that. You let that run for as long as it may be so that if something happens, it's there. Peace of mind. Lastly, power of attorney. Power of attorney is similar to a healthcare proxy, meaning if you are rendered incapacitated, and there's different types of power of attorney. There's durable versus non-durable. A durable power of attorney survives incapacitation. A non-durable power of attorney would be as simple as husband gives to wife the authority to sign at a closing. You buy a house, you go, you sign all those documents. You could give power of attorney to your significant other or the attorney to sign documents for that specific purpose. But a durable power of attorney says, I, Mac Long, give to my mother authority to go into my bank account, to sign the deed to my house, to sell, to change, anything. Basically what a power of attorney does is I'm giving all of the authority that I have personally to another person. So, big decision, not something we do willy-nilly. We want to make sure you understand, you know, this person now has a power of attorney, so if it's a kid that you're not so sure about and you give them the power of attorney, they could go to your bank with that and, you know, move money and things like that. So something to be concerned about. And forthright, you know, and we talk about all of this when we do this. Whenever I do a power of attorney, I make it abundantly clear just how powerful that is. As much as it seems like it's a simple 3, 4, 5-page document signed one time, you're giving the term signing your life away, essentially you're signing your life away. You don't remove the authority from yourself, but you've essentially duplicated yourself and allowed another person to act on your behalf. So we covered the will, covered the power of attorney, and we've covered the healthcare proxy. Those are my basics. If someone comes to me and says, I don't have any estate plan, that's the first thing I'm going to ask. Do you have a healthcare proxy? Do you have a power of attorney? Do you have a will? Generally speaking, I mean, depending on how complicated it is, we're talking $750 for a will, $350 for a power of attorney. I mean, you're all in for $1,500 if you're one person. 2 people, you're under $2,000. Just ballpark figures. Again, and I, you know, tailor that depending on how complicated we want to get. And oh, well, I want it to be this person and then that person, and you know, basic stuff. But just to have numbers in your mind of an idea. So for, you know, under $2,000, you can essentially take care of everything with one fell swoop. That will work for anyone. It just might not be the most ideal estate plan to avoid taxes, to avoid probate, to et cetera, et cetera, et cetera. So, because just by having a will, you're not avoiding probate. You have to probate a will. If you die with a healthcare proxy, a power of attorney, and a will, the healthcare proxy and the power of attorney cease to do anything once you pass away. The will takes over. The will, in order to be administered, has to be probated. Meaning the court, Massachusetts, if we're all Massachusetts residents, if you're in Rhode Island, it'd be Rhode Island probate, same thing. Similar, I shouldn't say the exact same, the rules are a little bit different, but very comparable. And the court essentially says, this will, it's legit, these people are the heirs, this person is in charge of the estate. Those are the basics of what, you know, why you do a probate. You get somebody appointed, personal representative, to act as the custodian of the estate and pass things in accordance with the will. I give this to this person, that to that person. The personal representative is the person that does that. So if all you have is bank accounts, no real estate, just, you know, financial assets with no tangible personal property, which is real estate, then a will, a POA, and a healthcare proxy are probably ideal. There can be more, you know, we can talk about trusts, I'll get into that in a little bit, but we get complicated with that and it's not always necessary. But in terms of, you know, just thinking on that with wills, POA, healthcare proxy, when you have a will, you, like I said, are probating this. If your assets are pay on death, meaning life insurance policies, anything pay on death, any of the types of accounts that you may have that are pay on death beneficiary style, those can be handled with the account itself. You name your life insurance policy beneficiary. You name the beneficiary to any other accounts. You put a person that you would want all of this to go to on your bank account, or somebody you trust on your bank account. If everything that you have and own, like excluding real estate, mind you, has your intended beneficiary's name on it, you can avoid probate. Because probate would give them the authority that they already have by having their name on the bank account, on the, you know, pay on death for a life insurance policy, anything like that. It eliminates the need to probate the estate. That is the overarching, you know, solution for most people for tangible, I mean, for, you know, monetary assets, bank accounts, life insurance policies, any other type of pay on death beneficial, assets. Now we move into real estate. Real estate, we can paint, I could sit here for 3 hours and tell you the millions of different ways we can cut that pizza up. But basic principles are, first and foremost, a life estate deed. Now, what a life estate deed is it gives you the right to live in your property, occupy your property for and during the term of your natural life. Basically, you own it till you die. Upon your death, it goes to this person. It gets recorded with the registry. The moment it's recorded with the registry, it's official. Reason for doing that: don't need to probate. Automatically happens. Avoid having to hire an attorney to do anything. You already did it. So if you're a single person or married, it's, you own your property jointly, survivor gets it automatically, but your child, your sibling, your whoever you want it to go to becomes what we call the remainderman. Not important that you know that, it's just a term that we use. The remainderman is the person that takes possession of the real estate upon your death. So I, Mac Long, give to Monisha Potter a life estate. Well, I actually reserve a life estate upon myself, remainder to Monisha Potter. That would mean that upon my death, Monisha would own my house, or whatever real estate that may be. You can do this with land, you can do this with a house, you can do this with commercial real estate. When we start getting into commercial stuff, again, we talk differently. If you have businesses, you have assets that are rental income, multifamilies, things like that. Not my favorite way to deal with that, just because of the complexities associated with that. So a life estate, I would say, is most useful when you have a home, whether it be a marital home or the home that you live in, and you want to leave that to someone or a group of people. It can be, there's no limit on how many people you can live. So you got 4 kids. I, Mac Long, live there for life. Remainder to my 4 children. Upon my death, my 4 kids own it collectively, 25% each. I will typically advise against that, if I'm being wholly honest, depending on how well your kids get along, because things get messy after we leave. You never know. And as an attorney, you see it all the time. Someone passes away, immediately one of the kids picks up the phone. How do I get my hands on X, Y, and Z? You'd be amazed. It's like, can we bury your loved one and mourn their loss, and then why don't you come in and we have a discussion? But people get weird with money, as we all know, and so it's important to think about that. If you're going to leave it all to 4 kids, it's 25%, and 3 of the kids want to sell, but 1 doesn't. Now we have a project. Or 2 of the kids want to sell and 2 don't. Project. Bigger issues, things to consider. So reasons why you would consider something like a trust, where maybe you have 1 kid who has their head screwed on very well, very straight, very, on top of things, and you make them trustee of the trust. Now, I'll dive into trust now because it fits right in with what we're talking about. Specifically, realty trusts. I am not talking about a trust in the term that a lot of people think of, which is for all sorts of assets. This is a specific realty trust for real estate only. I will get into the other types of trusts in a little bit. So a realty trust, the trustee is the person you name in the same way that you have a personal representative over the estate. The trustee is the custodian of the trust. So they manage the trust assets on behalf of the beneficiaries. Something that a lot of people do is put their home or multiple homes into a trust and name themselves as life beneficiaries in the same way that we were doing a life estate deed. Except now you've added a layer of protection. You've added a custodian to manage it all under the trust. It could be you with a successor. The thing with the trust is there's a lot. You can paint the picture however you want. A life estate deed, it's cut and dry. Me to you, that's it. There's no this much and that happens and then this happens. You can't do that. It gets too complicated and the deed doesn't work. A trust gives you more of an ability to say, for and during my lifetime, I'm the beneficiary of the trust. Upon my death, it goes to this person. But it goes to that person in terms of the beneficial interest. When we talk about selling the real estate, that one of the 4 children that has their head screwed on straight can sign the deed. can say, we can sit in a room and 4 of us can go down, or they can come and sit with the attorney and say, okay, 3 of the 4 agree on selling it. Sorry, but you're SOL, as they say, for the 3rd, 4th person that doesn't agree. They're going to get paid out. They're going to get their equal benefit of the house in the same way as the other 4, but we're not sitting here arguing over something that is just going to go in a circle around and around and around. And usually you could put a clause in there if you wanted that says any one of the beneficiaries has an option to buy the others out. So say that 4th, 5th, whatever person is like, well, I don't want to sell mom and dad's house. I love their house. I've lived there my whole life. Okay, well, you buy it from the other ones. Something you can put in there. Things like that you can't do with a life estate deed. And if you leave it to the 4 on a life estate deed, all 4, 5, however many people you left it to, have to sign the deed at the time of sale. So everyone has to agree. Mind you, a trustee can't act against the will of a beneficiary, but in terms of if 3 out of the 4 agree, the trustee can say, look, this is the benefit, this is what we all agreed on, majority rules, we're going to sell the house, everybody's getting their cut, whether it be a 5th, the 4th, whatever, of the proceeds of the sale. So, you know, reasons to do a realty trust, you know, or make it a little bit cleaner. It's also a good way, again, to avoid probate. If you don't do a life estate deed or a trust, a realty trust specifically, and you pass away with real estate, have to probate it. In the same way they give a bank account without a beneficiary on it, you have to probate it. To get somebody appointed to either leave the house to, and you write that in your will, we put that in the will. Think of a will as the fail-safe. If you did get struck by lightning, hit by a truck, what have you, I mean, if you get struck by lightning, God unfortunately isn't going to pay out on that. We don't have that kind of insurance. So as much as that would be lovely, point being is we have the will as the fail-safe. So if you die and all of a sudden you get an asset that you didn't account for during your lifetime, we have the will to catch that and avoid, you know, bigger probate, bigger taxes, etc., and make it nice and clean. But ultimately, if your estate plan is done perfectly, shouldn't need the will at all. Should be able to do everything that needs to happen without ever going to the attorney. Through real estate, through all of your bank accounts, etc., etc. So if you don't have your house in a life estate or in a realty trust and you pass away, you will have to have a probate. You'll have to get an attorney appointed, they'll have to go in, they'll file all the paperwork, they can charge however much money they see fit within reason, but I very rarely have seen the court say, oh, that's too much money. I saw an estate fee on a closing I did for 50 grand on a single family house, and I was floored, because it's honestly something that I would charge 3 to 5 grand for. But it's another attorney that's been doing it for 30, 40 years, and they can charge what they want. But the court doesn't ask questions, nobody else asks questions. I'm not gonna raise my hand on another attorney and say, hey, he's overcharging, even though I'd like to. Unfortunately, that would not go over too well. So, things to keep in mind. Something I will say, if you do find yourself in a situation where you need something probated, shop it around. Call a couple attorneys. Give them a basic idea of what your need is and what you've got to do, and see what everybody charges. Just like anything else, you're gonna get the floor done in your house, you call 3, 4 different people, you get a price. Not cheapest isn't always best, because you might get somebody that has minimal experience, so they're gonna charge you less. Also, most expensive isn't necessarily best. Just as I said, you might have somebody that charges you 40 grand for something that's $5,000 to $10,000. So things to keep in mind, food for thought. Moving on from there, we'll talk a little bit about trusts that are not realty trusts. There's 2 types of trusts, revocable versus irrevocable trusts. You may have heard that term before. Revocable, sometimes referred to as a living trust. You can make amendments to a living trust during your lifetime. Irrevocable trust, you can't change the trust. You can, however, create a new trust. So that is something to think about. I'll make that a little bit more clear. So revocable trust, you say, I want this to go to this person, I want this person to be the trustee, I'm gonna have this benefit, blah, 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 blah. Again, we could do a 50-page trust with all sorts of different rules and things like that. Is it necessary? Unlikely. If your estate's, 5 million plus, then I would say, okay, having a complicated irrevocable trust is probably necessary. best way to deal with things of that nature and scale, and when you start having multiple entities and streams of income and real estate and et cetera, et cetera. But if your estate is valued at less than 5 million, a realty trust is fine, but a revocable or an irrevocable trust may or may not be necessary depending on the complexity of your estate and assets. It's not purely value-based, because if you have one asset that's worth a lot of money, we can just take care of that with the best situation for that specific asset. But when you got a bunch of stuff all over the place, all over the country, all over the world, bank accounts here, this, there, and everywhere, irrevocable trust can work. Tax benefit-wise, I am not the guy. I will give you basic stuff, but I will tell, as I tell everybody, talk to the accountant. I don't get paid to know the tax law. Some attorneys spend time digging into that. Unfortunately, I do not have any interest in reading, 1,000-page tax code law books to figure out what makes sense. Rather pick up the phone and ask the accountant that specializes in that type of stuff. So other things to think about, and when we're talking about estate plans, is it's good to have your accountant and the lawyer on the same page. Because the lawyer might turn around and say, this makes sense, this makes sense, this makes sense, and then you talk to the accountant, he's like, well, actually this would make more sense. So it's good to have two opinions bouncing back and forth. The lawyer is more in terms of avoiding probate and shielding liability, things like that. Accountant is tax avoidance and best prepared way to avoid those things. I would say, generally speaking, that kind of covers most of what I'm going to talk about here.